Are you asking whether there's a meaningful distinction to be drawn between a religious institution and a charitable institution for the purpose?
No, I think there is. No, I'm not asking that because I think there is. What I'm asking you about is the comment from the Taxation Department, the Tax Office, that it's almost inoperative. This question of a religious group applying for a tax so they don't have to, put tax returns in. That it's inoperative. Is that your understanding of the research you've done?
I wouldn't be able to give you a view on that because I haven't looked at that particular question. So
is that a question that you'd want to look at?
Yes. Well, I mean, to the extent that you have categories in relevant statutes that may potentially have no application, that is something we would want to look at. One of the aims of our project is to make proposals about how to simplify the tax framework for not-for-profit activity. My colleagues who aren't here, both tax experts, and they'll be focusing on those questions.
Mr. Harding, Dr. Harding, there's never going to be an absolute, what's the word I'm looking for, operation of definitions of charities that is not controversial. Whether it's a trust or whether it's the ATO that does it or some other body, there's always going to be arguments, isn't there?
Absolutely. I think one fundamental insight is exactly that everywhere you turn, you will end up running into something that's intractable. So once you sort of accept that, it becomes a question of how competing interests and concerns get weighed and balanced. I think that's precisely what the presumption of public benefit has traditionally been aimed at doing. Sorting out how you reach decisions about charitable status in circumstances where it's just not clear one way or the other what to do on the basis of the evidence. Where it is clear, then the presumption really has no role to play, and that's where those cases about illegal or immoral purposes come into their own. But it's in those difficult grey area where, on the one hand, well, there's no evidence that what's being done is harmful to the public, but on the other hand, any evidence that there's a benefit takes the form of claims of intangible benefit, which is difficult to evaluate and assess. It's in that grey area that the presumption has operated and been effective up to date.
But the UK Charities Commission operate within the not the codification, but the common law that has operated for 400 years, and they then apply that in a more open and transparent way. Is that a good way to describe how they operate?
Yeah, I would say so.
In Australia, if there was an assessment of the 400 years of common law in Australia, it's not transparent, is it?
Well, as the law stands, no, it's very far from transparent. And indeed, there are inconsistencies in the law, and in some respects it's incoherent. So that is a very grave concern. I suppose our point's not so much that well, it's not at all, that the common law definition of charity is satisfactory. I think we would favour a statutory definition, and we would favour something that removes some of the, the more egregious excesses of inconsistency that we've found in the law up to date. For the purposes of the current inquiry, our point is that reform, well, it's already been the subject of detailed scrutiny and recommendations from numerous bodies over the years, but that reform is a larger reform than what this bill is directed at. And the danger of the bill is, in our view, that it will enact part of the reform in isolation from the whole, and then there'll be distortions and effects that were not intended.
So do you see the UK Charities Commission and the New Zealand Charities Commission and those other Charities Commission providing appropriate checks and balances that may not be in this bill?
I'm not familiar with the New Zealand system in details. I can't really...
Well, let's deal with the one you know about, the UK.
Yeah. Well, I'd make the point, first of all, that since the Charities Act has been brought into effect and the Charity Commission has issued its guidance on public benefit and continues to consult on that, we haven't yet seen flurry of litigation about definitional issues in the UK. Now, perhaps that's coming, but to date, it seems that that system has worked fairly well. And the absence of litigation usually does indicate that something's working well, and to that extent, it's an attractive model to think about. But if we were to see a whole lot of cases coming before the UK courts in which definitional issues were being disputed, then perhaps that view would have to be revised. But apart from that, as a sort of underlying principle, there being an independent regulator which has a guidance and advice issuing function is a very attractive feature of that.
Just very, very quickly, because I'm running out of time. As I understand it, there's an appeal process in the UK Charities Commission. Is that appeal process appellable to the High Court?
Yes, so my understanding is that you could appeal those matters all the way to the Supreme Court of the United Kingdom.
So the checks and balances are there?
Oh, yes.
Yeah, thanks.
Senator Xenophon?
I just have one question, Drs. Harding and Chia. At the moment, if there is a question mark over whether an organisation provides a public benefit or not, or if there are complaints, an organisation may have easily qualified for a public benefit with the Australian Taxation Office, but then there may be issues at a systemic level of that organisation. You can make a complaint to the ATO, but because of the nature of confidentiality of the affairs of taxpayers, you don't know anything more about it. Is that a fair summary of one of the inadequacies in the current system in terms of transparency?
That, to my mind, is yet another argument for there being an independent regulator of the sector. I mean, the arguments for and against regulation independently or within an existing organ of government have been canvassed elsewhere. But our view is that the appropriate regulation is done independently and transparently. And again, we would just reiterate the point that the UK model is a good one. The Charity Commission's website in the UK contains a whole raft of information that's simply not accessible in this country as matters stand, and that's to see that information there and to realise that it's possible to achieve that is quite an eye-opener.
And just finally, your study through the Australian Research Council, it's a three-year project. When will that be completed?
2012.
2012?
Yeah.
So will there be any interim reports coming out? Or?
Yes, we'll issue publications as we go.
Yeah.
There'll be, we're holding workshops, one's coming up in August. There'll be an international conference next year, and we hope to produce a volume of essays from that, and there'll be reports. Our first port of call, if you like, is on definitional issues, which will take in some of the matters that have been raised here, and of course among those will be the question whether we need a public benefit test. As I said at the outset, our view is not that a public benefit test is inappropriate, but we feel that it needs to be considered in a wider view than is proposed in the bill.
No, thank you. Thank you, Chair.